state may, if it wishes, allow people, not just reporters, but anybody, to do more things than the Bill of Rights requires them to do. Yeah. Let's see, how does that play out? I mean, it looks to me like there's a head-on conflict there, right? Where medical marijuana is permitted by California law and outlawed by federal law. And I suppose someday that may have to be decided by the U.S. Supreme Court, which will decide whether our law has to give way to the federal law. Yeah, as a general matter. Yeah, if there's a genuine conflict there, and if the federal law is constitutional, which would have to be decided. Mm-hmm.
My in this scenario is talking about the person who was accused of libel. They were reporting, and they're like, well, a witness or someone told me this, so I'm reporting the truth of that person, even though it's not the truth.
Yeah, we'll get to that when we get to libel. The question is whether when the reporter accurately reports what somebody said, which happens to be false and defamatory of somebody else, whether that's a defense, accurately reporting what a witness said. And the general rule there is no, that all you are doing is republishing somebody else's libel, and you are as liable as the original speaker for repeating the false and defamatory statement. We'll get to the ins and outs of that when we get to libel. So we'll revisit some of this stuff, but let's move on to, we've already outdistanced that, to the Due Process Clause of the 14th Amendment, which is a little tricky, but here's the way to think about it. The First Amendment says that Congress shall make no law abridging the freedom of speech or the press. That has been taken to mean that the federal government shall make no law abridging freedom of speech or the press. And by its terms, the First Amendment applies only to the federal government. And that's exactly what the framers of the Constitution intended. They definitely did not mean the First Amendment to apply to the states. One way we know that is by the existence of the religious clauses in the First Amendment compared with the reality of the time. That is, the non-establishment clause of the First Amendment. Congress can't make a law respecting the establishment of a religion. You have an official government religion. That's what they provided. But at the time the amendment was written, the states had official sponsored government religions. The states did. The federal government didn't. And that was forbidden by the First Amendment. But the states had Calvinist official religions in the north and Anglican official religions in the south. And it was the farthest thing from the framers' mind to deprive the states of the power to have their own sponsored religion. They thought surely that would continue. And then in the abolitionist days, in the 19th century, the southern states made it a crime to advocate abolition of slavery. And that didn't violate the First Amendment at all, because the First Amendment applied only to the federal government, just like the religious clauses. Then came the Civil War, and in the aftermath of the Civil War, the 14th Amendment, one of the 3, 13th, 14th, 15th Amendment, that dealt with slavery, that made former slave citizens, that empowered them to vote, and that provided in the 14th Amendment for equal protection of the laws, and included the Due Process Clause, which says that no state may deprive a person, we'll come to that with Citizens United soon, no state may deprive a person of life, liberty, or property without due process of law. And that amendment sat there virtually dormant that was 1868 when the 14th Amendment was enacted, right after the Civil War. And the amendment sat there virtually unused for the balance of the 19th century and into the 20th century, and until a case called Gitlow versus New York in 1925, when the court decided that the Due Process Clause of the 14th Amendment protected citizens against violation of the right to free speech in the same way that, against states deprivation of the right to free speech, in the same way that the First Amendment itself protects citizens against infringement of the free speech rights by the federal government. Let me say that differently. That was kind of mixed up. I'll do it by way of example. Benjamin Gitlow was a communist, basically. He was head of the Socialist Party in New York, and he distributed leaflets calling for a dictatorship of the proletariat, overthrow the capitalist system, and so on. And he's prosecuted not by the federal authorities, but by New York State, under a New York State law that prohibited doing that, being unpatriotic, basically, and taking positions opposed to government policy. Well, he was prosecuted and convicted in New York courts, and his case went to the Supreme Court of the United States, which came up with a bittersweet result for Gitlow. It assumed, we will assume that the word liberty, as protected by the Due Process Clause against state action, covers Gitlow. That is, the ability to proselytize, to leaflet, to speak, is within the liberty protected against state action by the Due Process Clause. It says no state shall deprive a person of life, liberty, or property without due process of law. Well, that liberty includes free speech, the court decided in the Gitlow case. Good news for Gitlow. Bad news for Gitlow, the Supreme Court affirmed his conviction, finding that what he had done was not included within the freedom of speech, that his subversive speech went beyond the line of protected speech. It had a bad tendency to upset government priorities and so on, and therefore was not protected by the First or 14th Amendment. So he won an important constitutional principle. He went to prison because the court misapplied the principle. So 1925, the court breathes life into the Due Process Clause, and what that means is that First Amendment principles apply to the states, and by states we include localities like the city of Berkeley. The University of California can be found to have infringed our First Amendment rights by some action it takes. It's an agency of the state. The First Amendment rights are applicable to the University of California and to any state agency or local agency through the vehicle of the 14th Amendment Due Process Clause. The First Amendment doesn't directly apply, but its principles are incorporated, as the court has said. They're incorporated in the word liberty in the Due Process Clause. Yeah. Well, if the law changes when? If the law changes before the appeal is decided, the court would apply the law as it is when they're deciding, the new changed law. But if the law's changed 5 years later and you've served your time, you're out, too bad. That's a very complicated subject. And I know that in some circumstances they would have to vacate your conviction because the underlying thing is illegal, maybe unconstitutional to punish you, and your punishment is continuing. They would have to vacate the conviction. But I think the general rule would be that once it's settled, it's over to them. After the Gitlow case in 1925, the case that we'll consider, I guess, a week from today, came to the court in 1931, Yetta Stromberg's case, and her speech was restricted by the state of California. She was convicted. Her case went to the U.S. Supreme Court, and the court said, well, Gitlow tells us that First Amendment principles apply to the states, and Yetta Stromberg's First Amendment rights were violated by this California law. That is the common law process, the common law method at work, which is the last feature that I want you to be conscious of. That is, the common law method is one of looking to what the court or the courts have previously decided, which are considered precedents. The precedent set by a previous decision under our common law system has to be followed by the court deciding the new case. That principle of being required to follow previous decisions is embodied in the Latin phrase stare decisis, which means something like let what has been decided stand. And that's sort of the heart of our common law system. More to be said about that, but do you have maybe you picked it up from Justice Scalia, the few pages of Justice Scalia's book, but do you have a sense of what the common law is? Can somebody say in a nutshell what the common law is?
In the precedents that they look at the analytical principle that underlay the case, and if that ruling applies to the facts of the new case, and those facts are different, then they have to go with that reason in making the decision.
That's a pretty good description of how the system works. But when the system finishes making the sausage, the result of it is a rule of law. Exactly, and that's what the common law system is. It's judge-made law. It's law made by judges deciding cases, as contrasted with law embodied in statutes passed by legislatures. And our system, the Anglo-American system, is very different from the system in most of the world. In Germany, you have the civil law system following the Napoleonic Code from the early part of the 19th century, where judges simply interpret statutes passed by the legislature, and their decisions do not have precedential value. That is, the judge in the next case, 2 years down the line, is not obligated to follow the earlier decision. The judge is allowed simply to interpret the law the way the judge thinks the law should be interpreted. Whereas under our system, under the doctrine of stare decisis, the court in the second case is obligated to follow the holding of the previous case. And the holding, you can look it up in the glossary, the holding is the rule, the principle that the first court necessarily decided in deciding the first case. And that's the holding, what the court decided. They decided that racially segregated schools, in 1895, they decided that as long as states provide separate but equal facilities, that doesn't violate the Equal Protection Clause of the 14th Amendment. Then in Brown versus Board of Education in 1954, the court is confronted with that precedent from 1895. And instead of following that precedent, as it would be required to do under the doctrine of stare decisis, it overruled the earlier decision. So that's not good law anymore. Under our law now, it's a denial of equal protection of the laws to have racially segregated schools. That's an extremely rare event where the court will overrule a prior decision. Much more commonly, the court will distinguish a prior decision and say, well, the facts in that case were very peculiar, and this was the situation, whereas here, in the case that we now have to decide, the facts are completely different, and therefore the holding of the previous case doesn't apply here. We're free to decide it without giving any weight to the previously decided case. But the way the system is supposed to work is that a court must follow the precedent, and it's not precedence. It's used different. I see that all the time. Get rid of the word precedence for this course. That's not the right word. Something may take precedence. An argument may take precedence over a weaker argument. That's not the common law system. That doesn't get rid of the word precedence for this court. Just think about precedent, the plural of which is precedents, T-S, not precedence. And think in terms of there's this precedent that we have to deal with. Are we going to follow it? Are we going to distinguish it? Or are we going to overrule it? The common law, as we'll use it in this course, we'll use it in two ways. One, we'll talk about the common law rule, what the substantive rule of law is. In a libel case, there are certain rules, like In order for there to be liability, there has to be falsity. There has to be defamatory meaning. So those are rules developed by judges in deciding cases. Those are common law rules of law. And we'll talk about the common law as a method. And the common law method, which we inherited from England, I guess there's a little more to that story, the common law method applies even in non-common law cases, that is, even in constitutional cases, so that in deciding a First Amendment issue, the court uses the common law method. It looks to its precedents and decides whether they apply to the fact of this case. That's what we'll do when we look at Morse versus Frederick on Tuesday. The court has to confront 3 of its important precedents in order to decide whether high school students have a First Amendment right to speak. See you then.